Hey, how's everybody doing? I wanted to go through this section. The county recorder had mentioned Ohio Revised Code 317.08 is what the prosecutor had given her, and this is the excuse given to me by the county recorder, Cindy Rodgers, as an excuse as to why she refused to file the document that I was uh, wanting to be acknowledged. Um, so what I'm going to do is I'm going to read through this. This is, if you want to look it up and follow along, you can pause the video. This is from codes.ohio.gov uh, / Ohio Revised Code / section 317 .08. So if you want to look that up, you can follow along. Section A. The county recorder shall record all instruments in one general record series to be known as the official records, quote unquote. The county recorder shall record in the official records all of the following instruments that are presented for recording upon payment of the fees prescribed by law. 1. Deeds and other instruments of writing for the absolute and unconditional sale or conveyance of lands, tenements, or hereditaments. 2. Notices as provided in sections 5301.47 to 5301.56 of the Revised Code. 3. Judgments or decrees and actions brought under section 5303.01 of the Revised Code. 4. Declarations and bylaws and all amendments to declarations and bylaws as provided in chapter 5311 of the Revised Code. Looks like it cut off the particular section. Let's see. 5. Affidavits are provided in sections 5301.252 and 5301.56 of the Revised Code. 6. Certificates as provided in section 5311.17 of the Revised Code. Section 7. Articles dedicating archaeological preserves accepted by the Director of the Ohio History Connection under section 149.52 of the Revised Code. Section 8. Articles dedicating nature preserves accepted by the Director of Natural Resources under section 1517.05 of the Revised Code. Section 9. Conveyances of conservation easements and agricultural easements under section 5301.68 of the Revised Code. Section 10. Instruments extinguishing agricultural easements under the section 901.21 or 5301.691 of the Revised Code, or pursuant to the terms of such an easement granted to a charitable organization under section 5301.68 of the Revised Code. Section 11. Instruments or orders described in Division B, subsections 2B of section 5301.56 of the Revised Code. Section 12. No further action letters issued under section 122.654 or 3746.11 of the Revised Code. Section 13. Covenants not to sue issued under section 3746.12 of the Revised Code, including all covenants not to sue issued pursuant to section 122.654 of the Revised Code. Section 14. Restrictions on the use of property contained in a no further action letter issued under section 122.654 of the Revised Code. Restrictions on the use of property identified pursuant to Division C 3A of section 3746.10 of the Revised Code, and restrictions on the use of property contained in a deed or other instrument as provided in Division E or F of the section 3737.882 of the Revised Code. Section 15. Any easement executed or granted under section 3734.22, 3734.24, 3734.25 or 3734.26 of the revised code. Section 16. Any environmental covenant entered into in accordance with sections 5301.80 to 5301.92 of the revised code. Section 17. Memoranda of trust, as described in Division A of Section 5301.255 of the revised code that describes specific real property. Section 18. Agreements entered into under Section 1506.44 of the revised code. Section 19. Mortgages including amendments, supplements, modifications, and extensions of mortgages or other instruments of writing by which lands, tenements, or hereditaments are or may be mortgaged or otherwise conditionally sold, conveyed, affected, or encumbered. Section 20. Executory installment contracts for the sale of land executed after September 29, 1961, that by their terms are not required to be fully performed by one or more of the parties to them within 1 year of the date of contracts. Section 21. Options to purchase real estate, including supplements, modifications, and amendments of the options, but no option of that nature shall be recorded if it does not state a specific day in your expiration of its validity. Section 22. Any tax certificate sold under Section 5721.33 of the revised code or memorandum of it that is presented for filing of the record. Section 23. Powers of attorney, including all memoranda of trust, as described in Division A of Section 5301.255 of the revised code, that do not describe specific real property. Section 24. Plots and maps of town lots, of the subdivision of town lots, and of other divisions or surveys of lands. Any center line survey of a highway located within the county, the plot of which shall be furnished by the Director of Transportation or the county engineer, and all drawings and amendments to drawings as provided in Chapter 5311 of the revised code. Cuts it off. Section 25. Leases, memoranda of leases, and supplements, modifications, and amendments of leases and memoranda of leases, including a lease described in Section 5301.09 of the revised code. Section 26. Declarations executed pursuant to Section 2133.02 of the revised code and durable powers of attorney for health care executed pursuant to Section 1337.12 of the revised code. Section 27. Unemployment compensation liens, internal revenue tax liens, and other liens in favor of the United States as described in Division A of Section 317.09 of the revised code. Personal tax liens, mechanics liens, agricultural product liens, notices of liens, certificates of satisfaction or partial release of estate tax liens, discharges of recognizances, I can't say that, excise and franchise tax, liens on corporations, brokers' liens, and liens provided for in Section 1513.33, 1513.37, 3752.13, 4141.23, 5111.022, or 5311.18 of the revised code, and Section 28, corrupt activity lien notices filed pursuant to Section 2923.36 of the revised code, and Medicaid fraud lien notices filed pursuant to Section 2933.75 of the revised code. Section B, all instruments or memoranda of instruments entitled to record shall be recorded in the order in which they are presented for recording. The recording of an option to purchase real estate, including any supplement, modification, and amendment of the option under this section shall serve as notice to any purchaser of an interest in the real estate covered by the option only during the period of the validity of the option as stated in the option. Section C. In addition to the official records, a county recorder may elect to keep a separate set of records that contain the instruments listed in Divisions A-24 of this section. Section D. As part of the official records, the county recorder shall keep a separate set of records containing all transfers, conveyances, or assignments of any type of tangible or intangible personal property or any rights or interests in that property if and to the extent that any person wishes to record that personal property transaction, and if the applicable instrument is acknowledged before the notary public, and if the applicable instrument is acknowledged before the notary public. If the transferor is a natural person, the notice of personal property transfer shall be recorded in the county in the state in which the transferor maintains the transferor's principal residence. If the transferor is not a natural person, the notice of personal property transfer shall be recorded in the county in which, in this state, in which the transferor maintains its principal place of business. If the transferor does not maintain a principal residence or a principal place of business in this state, and the transfer is to a trustee of a legacy trust formed pursuant to Chapter 5816 of the Revised Code, the notice of personal property transfer shall be recorded in the county in this state where the trustee maintains a principal residence or principal place of business in all other instances. The notice of personal property transfer shall be recorded in the county in the state where the property described in the notice is located. And that's the end. It has a little italicized portion here. But anyway, so that's Ohio Revised Code 317.08 that the county recorder gave to me, which I recorded. If you listen to the conversation, the county recorder, Cindy Rodgers, told me, this quote-unquote elected official told me that Ohio Revised Code 317.08 is the code that explains or describes or authorizes her to refuse to file the document that I had submitted for that I needed acknowledged, the instrument that I needed acknowledged. There is nothing in that code first of all that allows her to refuse to file the document. It says in many different places it refers to different types of instruments in which in many different sections of this particular Ohio Revised Code, it would actually apply. It's the opposite. What she said is wrong, and this is because she doesn't know what she's doing. She doesn't know how to do her job that she was elected to do, supposedly, quote-unquote, elected to do. She's going by what someone else is telling her. She admitted it in the conversation. She's going by what Mark Zangi told her. And when I asked her, you heard it in the conversation if you listened to it, when I asked her specifically if she read it to verify what she was told is accurate and true, what her answer was not yes or no. What her answer was I'm aware of the code. So you see now how it works, even at this level. See, I thought Cindy Rodgers was somebody that could be trusted. I had a few interactions with her in the past, and she was very open and friendly and seemed seemingly honest. Now all of a sudden there's a change of character. Now all of a sudden she's hiding behind the prosecutors and someone else's word. She's using hearsay to justify her own dereliction of office, the dereliction of her own duties. It's not Mark Zengi's responsibility to know what her job is. It's her responsibility to know what her job is. That's the whole point of her being in that position, right? Well, I think this is just my opinion, if someone doesn't know what they're doing, if someone has to reach out and ask someone else for their opinion on how to do their job, on something as basic as recording a document, recording an instrument, and then using that hearsay as some kind of excuse to excuse the dereliction of duty in her particular position or in that office. So this is just another example. There's probably more, I guess, important things to some of you out there that's going on than, what I'm dealing with and what I'm exposing here. But, there's a saying, it's the little foxes that spoil the vine. It's not always the big in-your-face things that cause the most destruction. Sometimes it's the little things that go on in the background that tend to fester and turn into a cancer or something worse. After all, it only takes a small spark to start an entire forest fire. So if you think about that context in both in a positive manner and a negative manner, a positive spark or a negative spark, it only takes something very small to cause very big ramifications. So what I'm exposing here are some of these failures, I guess, inabilities, ineptness, incompetence. And again, this comes back to the lack of accountability. These people aren't challenged enough. These people aren't, how should I say, they don't have enough required of them to meet the qualifications to be put in that position. Because obviously they don't even know what they're doing if they have to ask someone else how to do their job. Not a supervisor, they're asking a county prosecutor, whom as I've already made very clear and evident, I've got plenty of evidence of how they operate. And isn't it just ironic that she uses the prosecutor's office, Mark Zengi, as an excuse for her dereliction when, how about that? The prosecutor's office just recently, I guess, filed some paperwork in the court or filed a complaint or accepted a complaint. I'm not quite sure what they do because they don't bother paying attention to any of my complaints, ironically. All my complaints get ignored, but when their buddies submit complaints, when other shyster, pettifogger attorneys file complaints, of course they pay attention. They're right on that. See the favoritism? See the nepotism? It's blatant. It's obvious. Look at the court record. It's more than obvious. And here we've got another public servant, so-called elected official, that doesn't know how to do her job, that uses someone else as a scapegoat, as an excuse. But the funny thing is if there isn't really any accountability, why not just tell me no? Why use someone else as an excuse? Is that maybe a sign that, like I said, she just doesn't know what she's doing? She lacks the confidence to be able to um control that position and just tell people no, even though it's unlawful. She has to use the prosecutor's office because she's too weak to manipulate people. So she has to bring in someone else to add a little bit more clout to the excuse. Oh, well, the prosecutor said so. What are you going to do about it? The prosecutor said it. Oh, I don't know. I'm aware of the Ohio Revised Code, but the prosecutor said it. See how that works? Quite frankly, this individual should be recalled. She may be able to be a decent secretary at times, but the refusal to do her duty that she was put in place supposedly to do is a direct violation of her oath of office. I think, if I remember correctly, I just had a conversation with her a week or two ago about oaths of office, and she mentioned to me that she had a copy of her oath of office. So I'll have to make sure and get a copy of that oath of office and hold her to that. Unless that doesn't mean anything, unless that's just something arbitrary that they do just, for posterity's sake. I mean, I thought it was actually for them to have a set standard, if you will, that they have to abide by. At least that's part of that standard. There's a lot more to it, but that's a huge portion. And if they're not following their oath of office, what's the point of having it in the first place? It's just arbitrary. But according to the law, it's not arbitrary. It's required. And if they don't have their oath of office filed in the proper places, and especially if they're not following that oath of office, that's a direct disqualification for being able to hold that office or that position. So here you go, another public servant from Zanesville, supposedly serving Zanesville, but refusing to do her job. Again, you can go back and read through it. I didn't read anywhere in that particular Ohio Revised Code that stated that the county recorder has the authority to refuse to record a document. It described a multitude of different types of documents that shall be filed, and particularly the different types of records that these particular filings are kept in, or the records are kept in. So, yet again, it's another lie. I wonder if she's an attorney. I'll have to look into that, see if she goes by Esquire too. Probably not. She's probably one in training. That's probably why she had to reach out to the prosecutor's office, because she doesn't know what she's doing yet. But, yeah, for all you out there that think your vote matters and that vote for these people, this is what you're paying for, so to speak. I mean, I guess you get what you pay for.